37. Certificate of merit. Remember, it's medical, dental, podiatric, and residential foreclosure for represented plaintiffs only. 38. A motion to amend or supplement pleadings shall be accompanied by the proposed or amended pleadings clearly showing the changes to be made to the pleadings. 39. Which are true? So this is a similar question to one that was on the last quiz, so hopefully you got it right. A defendant may proceed against a party who is or may be liable to the defendant for all or part of the plaintiff's claim against him by filing a third-party summons and complaint at any time after the defendant's answer. So one is wrong. The defendant must also serve a copy of, not the summons, it's the complaint only on plaintiff's attorney. And the third-party plaintiff must pay a separate index number fee, but does not get a new index number. So that was the only one that was true, so the answer is D, 3 only. The things that were wrong with the 2 was that it's only the complaint, not the summons, because the original plaintiff, he doesn't need a new invitation to court. He started the action, and that's what a summons basically is. It's a invitation you cannot refuse to court. And 1 is wrong because it's after the defendant serves his answer. He has to serve his answer first, then he could file a third-party summons and complaint. 40. Failure to comply with a subpoena issued by a clerk, attorney, or judge, so basically a judicial subpoena, shall be punishable as contempt of court. So when the clerk or the attorney is issuing the subpoena, they're not acting as a clerk or an attorney. They're acting as an officer of the court issuing the subpoena, and it's contempt of court if you fail to comply with it. 42. This is actually 3001. A party who has brought a claim for personal injury or wrongful death against another party may maintain a declaratory judgment action directly against the insurer of such other party. 43. True or false? When relief against a mistake is sought in action by way of defense or counterclaim, relief shall not be denied merely because the mistake is one of law rather than a fact. Now that's true. Again, I don't think they're going to go there with this on a senior exam, but I guess it used to be that the mistake had to be a mistake of fact. Now it can be either one. So an action for mistake, it can be a mistake of law or fact. 44. There shall be an answer to a counterclaim denominated as such. An answer to an interpleader complaint or third-party complaint, and an answer to a cross-claim only if the cross-claim contains a demand for an answer. If no demand is made, the cross-claim shall be deemed denied or avoided. So, there's always an answer to any complaint except a cross-claim. A cross-claim only gets an answer if there's a demand for an answer contained in the cross-claim. Otherwise, the cross-claim is deemed denied or avoided. 45. The complaint must be served with the summons. That is not true. You can serve a summons with notice, and then the defendant would serve a demand for the complaint. 46. In an action designated by the insurance law for personal injuries in the car accident case in this state, the complaint shall state the plaintiff has sustained a serious injury or economic loss that is greater than basic economic loss. And the reason that is because we have no fault insurance law in New York, so you cannot sue for regular injuries. It has to be a serious injury. 47. A verification. This is very important. What is a verification? It is a statement under oath that the pleading is true to the knowledge of the deponent, except as to matters alleged or on information and belief. That's a typo. It should say on. And that matters. As to those matters, he believes it to be true. So a verification essentially is a statement under oath that the pleading is true to the knowledge of the deponent. The deponent is the person that signs it. So when in criminal, when there's a verification done, the deponent is usually the cop. 48. This is true. The court may permit pleadings to be amended before or after the judgment to conform them to the evidence upon terms as may be just, including granting of costs and continuances. 49 is true, except the first sentence is true, the second sentence is false, so this whole thing is false. Pleading shall be liberally construed. That is true. I want you to know that that is true. But defects shall be ignored, not corrected, if a substantial right of a party is not prejudiced. 50. A motion to quash, fix conditions, or modify a subpoena shall be made promptly in the court where the subpoena is returnable. And 51. If a subpoena is not returnable in a court, so it's returnable in front of an administrative board or something like arbitration or something, first, a request to withdraw or modify the subpoena shall first be made to the person that issued it. And a motion to quash, fix conditions, or modify may thereafter be made in the Supreme Court, except if the motion is about a child support subpoena, it can be made to Supreme Court or to family court. So child support subpoena, Supreme Court, or family court if it's not returnable in a court.